Okay, so as I mentioned, I'm going to take a moment to introduce our speakers who will be presenting on family law financing. First, we have Tim Andrews, and Tim Andrews brings 25 years of experience working in several sectors, including legal and finance, to his role at BridgePoint, where he leads the business development team and devotes much of his time to creating awareness for the company's legal solutions. He is also involved with product development and evolving existing solutions to best address the needs of lawyers and reflect ever-changing market conditions, including being instrumental in the development and launch of BridgePoint's family law financing. Tim truly appreciates the opportunity to meet with lawyers to discuss their individual needs, discover more about their firms, and provide solutions relevant to their practices. Thank you so much for being here, Tim, and for all of your support for this event.
Absolutely. Thank you, Shannon.
Next, we have Carrie Heinzel. Welcome back, Carrie. We had Carrie on for a couple of programs yesterday. It's always great to have you here.
We're leaning into Carrie pretty hard, these last couple of days.
It's my pleasure.
And for anyone who didn't join us yesterday, I'll just take a moment to introduce Carrie again. Carrie Heinzel is the founder of Fairmore Family Law Financial Solutions. Fairmore offers independent fact-based financial analytics and settlement insights to individuals and couples working through separation and divorce. Carrie is an active collaborative process trainer, co-teaching the introductory program for new collaborative professionals and advanced level trainings for seasoned practitioners. She sits on the board of directors for York and Durham Collaborative Practice and is the president of the OACP. Carrie has taught statistics, research methodologies, and psychology at college and university levels. In addition, Carrie has presented at conferences for the OACP, Family Dispute Resolution Institute of Ontario Annual Conference, and the IACP. Thanks again for being here, Carrie. And next we have our very own Natalie Derbyshire. Natalie was called to the bar of Ontario in 2006.
A long time ago.
She provides
was there computers back then, Natalie?
There were, but I think it was like a Commodore 64.
Floppy disk.
Yeah.
Sorry, Shannon, we keep throwing you
No,
off.
that's okay. I had a tickle in my throat, so that gave me a minute to recalibrate over here. I appreciate the interlude. Natalie provides clients with peace of mind through sound legal advice and helps them navigate separations confidently. Focusing on dispute resolution processes like collaboration, mediation, and negotiation, she aims to save clients money and achieve reasonable settlements. Specializing in supporting vulnerable clients, particularly those affected by family violence, Natalie offers legal knowledge, safety measures, and therapeutic resources. A certified collaborative practitioner since 2011, she serves on the board of directors for Collaborative Divorce Toronto and chairs its membership committee. She also serves on the board of directors for the Family Dispute Resolution Institute of Ontario and co-chairs the Family Violence section. Thank you for being here, Natalie. And
thank you for having me.
My pleasure. And I'm just going to give a brief overview of what our speakers will be discussing today as part of their presentation. And what you can expect to learn over the course of the next hour. So we have expected costs of separation, financial challenges of divorce and separation, the retainer agreement, common approaches, and Tim will be sharing about BridgePoint Financial Services, and then we'll have some final thoughts from all of our speakers. So I'll let you take things away, Russ.
Yeah, let's run our first poll, Shannon, if you don't mind. And we do have some audience questions that have come in. So thank you, everybody. Send your questions in. Please participate in the polls. First poll is, how do your clients finance their divorce and separation? And a question that we're going to kind of lean into you heavily, Tim, not because you're the sponsor, but because you're kind of a unique spot where there's third-party financing for family law litigation. A lot of lawyers don't even consider this as an option. I know up until a few years ago, neither did I. But is financing available if a client hasn't even retained a lawyer yet?
Yes, I mean, we do look at pre-retainer amounts just to, because at the end of the day, it ends up being an access to counsel issue. So we are able to look at certain files and clients pre-retainer just to, ensure that they are able to start working with a lawyer and getting the information that they require for any further funding that they need during the process.
Okay, good to know. Thank you. So let's see what our audience is thinking. How are people paying for their divorces? Can we get our poll results, Shannon, when you get a minute? All right, cash and savings, 60%. Credit card, line of credit. Yeah, it's quite common if they have credit on their credit card anymore, 60%. Family and friends, 56%. It's surprising how many family members step in, right? I know when I meet clients and you think this person doesn't have a pot to piss in, how are they going to afford a lawyer? But the family steps in, they don't want their child or their brother to get railroaded and pays the bill. So that's quite common. Lawyer defers retainer payment, 24%. I'm surprised that it's so high. Third-party financing, 12%. And other, please put it in the Q&A. So thank you, everybody, for sharing those. It's very interesting. Let's talk about expected costs of separation. So I'm going to fire through a bunch of things. And Carrie, Nat, you tell me what your numbers are, and I'll tell you if I think that's consistent with mine. And Tim, if you want to pike in on this as well.
Mm-hmm.
All right, so a collaborative practice file, what's the cost? Like these kind of trick questions, right? Because I know it all depends, right?
Yeah.
Give it the ballpark. I've got a number in mind. Carrie, what do you think it's going to cost? And using
If you're doing a full team, I'm going to say 15 per person.
per person, Nat?
Yeah, I would say typically an average of total cost somewhere between $30,000 to $40,000.
Oh man, you guys are pricey. I was going to say 5 to 20,000, but
Well, wait, are you talking about per person or in total? Like just
yeah,
like,
well, I guess it's consistent. That might be my client's cost. So yeah, so 40 maybe would be in the ballpark. Yeah, at the high end.
Mm-hmm.
All right. So divorce. So basic, there's no such thing as a simple divorce, but let's just say you can get one through. I would estimate, 2,000-3,000. A lot of that's disbursements, right? Is that consistent with what you guys are saying?
yeah, 100%.
All right. For the next few, I put a big question mark. Contested divorce, property issues, support issues, parenting issues, and complex divorce. That's all over the map, right? You can't really give an estimate on those. What would you say, Nat?
Gosh, I mean, I hate to say it, but the sky's the limit, and it really is dependent upon the level of cooperation between the parties, whether or not people are providing their disclosure and acting in a transparent manner. So yeah, I would probably say somewhere in the range of $50,000 to $70,000 if it's high conflict.
You think
and it can go up from there.
If it's CP and they're playing nicey nice, these cases can get up to 40,000. So you can imagine if you're not playing nicey nice and you're running off the court for every dispute. Carrie, what do you think?
I think everything is behavior dependent. So if you're going to have good behavior, both parties are operating with reasonable and good behavior, your costs are going to be much lower. If you're going to have bad behavior, it is going to cost you quite possibly everything you have. I know of people that have spent over $250,000 in process alone and didn't get finished. And that's not paying their settlements.
Yeah. Tim, what are you seeing in terms of your clients?
Well, I think, I agree.
Your clients also including lawyers who turn to you for litigation financing.
Right. I mean, yeah, unfortunately, yeah, the sky is the limit. And I think that, also something that dictates it is what the anticipated equalization or entitlement is, because, people are only going to go so far, with the funds that they are anticipating receiving.
Yeah.
And the last thing you want is a novel case, right? Where you have $500,000-$600,000 that can go either way.
Mm-hmm.
People spend $100,000 to litigate that issue potentially. Yeah, I agree with everybody. It's all over the map. For me, when I have clients ask me about costs, the biggest factor is who their spouse is going to retain as counsel. And I hate to say that because that's going to dictate what process we go in. If they retain somebody with collaborative practice training who wants to use a full team and focus on goals and interests, we could probably manage that. If they retain one of these lawyers who are, an arsonist or a warrior, just want to burn everything to the ground. We all know who these people are. We work with them. They're in every city. Like Carrie said, sky's the limit. They're going to litigate until that file runs out of money, until they get fired, or until most of them go right up to the first day of the trial and then file a form, get off the record. A handful of them will actually conduct the trial, but they don't have a proper retainer to do so. Maybe I'm being a little bit sarcastic, but this has just been my experience. But would you agree generally, Nat, that the opposing counsel is really also
It's
going to be
critical.
a factor in dictating the costs?
I actually try in my initial letter to the spouse to persuade them to retain collaborative counsel for that reason.
Yeah, yeah. And a lot of people don't know, right? Because I've brought in runaway train high conflict cases after 2 years. Explain the collaborative process, and they said nobody told them about that. If they'd known 2 years earlier, they probably would have saved $100,000 in fees and not gone to court for 2 years. Okay, so let's go next topic. Experts, price range. What are you seeing, Nat?
Geez, again, the sky may be the limit depending upon how you conduct your case and whether or not you're wanting to have expert reports. So paying for your lawyer, obviously that's probably going to be one of your largest expenses.
But I'm thinking if you have to retain an expert, let's say a CBV or parenting professional, what kind of cost would you be estimating?
So I would say roughly at a minimum, anywhere from $10,000 to 30. I've seen more than 30 in very complex business valuations and income analysis reports. It's just dependent upon the nature of your business and how the structure.
Yeah. Carrie, what are you seeing at your end?
Yeah, I think Natalie's estimates are right. At the end of the day, this is going to come down to complexity. So if you have a very simple business, you're a sole proprietor, or, a very simple structure, that's going to look very different on your costs. If you have a full corporation with a lot of employees and land and everything else, that business valuation is going to get a lot more complex, and therefore the cost of that is going to be a lot more. It's really going to the more complex you are, the more this is going to cost to unravel, because we want to get it done right.
Got to give a plug. This afternoon, we've got certified business valuator reports. So if you want to learn more about what we're talking about, stay tuned. We've got some great experts coming in this afternoon. I would agree. I'd say, 5 to 50,000 would be the general range. It depends what kind of report you want. If you're getting an oral report, it's going to be a lot less expensive. But recently I had an expert do a company valuation, and we got up to 40 grand pretty quickly. I didn't understand why it got so expensive, but there's multiple holding companies with, strange shareholder arrangements, and it took quite a bit more work than I was expecting. So, Tim, you're seeing pretty much the same thing at your end, or?
Yeah, and I would agree. I mean, it's dictated by the complexity. I think some of the more substantial ones we see are business evaluations, and then even in getting into forensic accounting, when one party is trying to locate, any monies that haven't been truthfully submitted.
Yeah.
Yeah.
All right, case management. So we're talking about case conferences, settlement conferences, trial management conferences, continuing case conferences, all the rest of it. Exit free trials, I would say $2,500 to $5,000 a pop, including preparation of the brief. Nat, does that feel about right?
Yep, I think that's correct.
Yeah. Trials, pre-pandemic, when I used to do a lot of these in person, I would tell my clients $5,000 a day. We would just run a block fee. That actually saved the money because I usually work late at night on the case and early next day, and sometimes I'd be out of town at a hotel. But generally $5,000 a day. I think it'd probably be more expensive now, maybe not. And probably $25,000 to prep for trial. Trial records, document briefs, witness prep, and trials can go from $100,000 to $200,000 if you're into it for 10, 14 days. What's your experience for trials? Does that sound about right, Nat?
Yeah, I would say in general, you're going to spend over $100,000 throughout litigation at a bare minimum if you're going to trial. That's been my
Yeah.
experience.
Yeah. Appeals, we don't talk about appeals too much. When I'm unsuccessful, happens, I flip it over to Aaron Franks at Epstein Cole. He's sort of my go-to appeal lawyer. There's a plug for Aaron, our case 2024 case presenter from yesterday. Fantastic job, and Adam as well. But generally, I don't think I've had an appeal cost less than $20,000 for even the simple ones. And if you have motions at the Court of Appeal, it goes through the roof. So appeals can be incredibly expensive. And if you're ordering the transcripts, add another several $1,000s on for transcripts. What's your experience at the appeal level, Nat?
At least $20,000, and that's because of the preparation involved. At my most successful appeal, we didn't have to make submissions, so that was nice. The judges didn't require it of us because the written material was so well done. But yeah, at a minimum, I would say 20,000, and again, it can be much higher just depending upon how many days you're having to attend.
That's some pretty good advocacy, Nat. When they don't want any submissions, that means you've done good, right?
It's all about the preparation.
With me, they just said, we need to hear more. You haven't said anything yet, right? Come on. Don't you have anything? Okay, so what are some, all right, let's go to our next poll, see what our audience is thinking. Thank you, everybody. It just gives you a flavor of the costs that we're seeing on a day-to-day basis practicing family law. Your costs may be different. They could be much higher. Maybe if you're in a smaller community, those costs may be lower. I know a lot of family lawyers don't even do trial work. They refer it out. So it gives a sense in terms of what we're looking at. So next poll, what are some of the financial challenges your clients experience during divorce? So it'll be interesting to see what our audience has experienced. Most of our audience today, 80% or more, are family lawyers or other lawyers. So this will be a good one, but let's see if we've got another question we can give to Tim. Maybe Carrie can answer this one too, but we'll start off with Tim. Why would a client use family law financing over a credit card? Oh, I think probably the interest rate might be the answer, but what's the answer there?
Yeah, generally, yeah, the interest rate is lower, but there are a few other benefits compared to a credit card. One is monthly servicing. As you know, when you carry a balance on a credit card, you have to pay minimum payments, and that can be really tough if a person's in a position where they're trying to make ends meet during the process. And then the other big factor is monthly compounding. So any amount that that you leverage on a card, that interest is compounding monthly. Whereas with, at least with BridgePoint, we only compound biannually. So those are the two big benefits. And then also repayment is only due upon resolution of the separation or divorce.
And if it's a spouse without credit or an income, they may not be eligible for a credit card.
Exactly, yeah.
Yeah.
So we don't do a credit check, and there's no proof of income required either.
Carrie, what do you think? Line of credit.
Yeah, I have to agree with Tim. If you're paying like 21% interest on your credit card, it's really not a great use of money. The other thing I like about this idea of financing available to you, it's cash flow. That becomes so difficult when you're starting to go through separation, divorce. Like, we wanted you to be able to live still. You need to be able to live still. So if we can find options for you that allow you to give you that breathing room, let's get you that breathing room.
Well, especially if you got to get a second home or a second apartment, right?
Well, yeah.
That's much, right? All right, let's see our poll results and what our audience is thinking. Thank you, Shannon, for assisting. All right, paying for the lawyer, yeah, 75%. Getting a new home apartment, 55%. Pursuing support claims, 56%. Waiting for equalization, 50%. Living expenses, 49%. Other 10%. You can put that in the Q&A box. Really, everything, right? According to that poll is what we're looking at. Okay. Next, financial challenges during the divorce. Well, let's hear what our experts think today. accessing equity and delayed equalization payments. Tim, you want to speak to that a little bit?
Yeah, I mean, I think the biggest factors that contribute to the financial challenges during the divorce process that we see is, equities tied up in the matrimonial home, so they can't access that. Any investment accounts are locked until settlement. There's, and we touched upon it just now, there's a requirement for living arrangements, and that becomes even more important in high conflict cases as well as domestic abuse where people need to escape the matrimonial home. So that's a very big one. And I'm sure we'll get into a lot of it, but there's the private mediation or arbitration costs that are involved, and generally no access to common financial assets. In a lot of circumstances, one party is a lower or non-income earner, which puts them at a significant disadvantage. And then again, what we spoke about in the last segment, which was your disbursement costs, so your expert reports and business valuations.
All right. So now, what about accessing or retaining counsel? How do you work with clients when they're faced with that challenge?
Well, often people ask me immediately whether or not they're allowed to draw money from their joint line of credit. And the answer is that depends on whether or not you're in the collaborative process.
Yeah.
If it's joint, yes, the answer is you do have access to it. And sometimes clients beat one another to the punch, right? Spouses will race to the line of credit to see who can withdraw first. And then that ends up being one of the first urgent issues to resolve.
Or if the spouse is being mean-spirited, they just simply cut the credit cards off, right? Or,
That too. And if there's a pre-existing unequal playing field, as Tim had mentioned, it's usually worsened.
Yeah, it could be really tough. And that's when I see a lot of family and friends stepping in, right? They realize they may or may not get paid back later, but they're certainly not going to let their family member go without a lawyer helping them. Disbursement costs, we see this quite often in the collaborative setting. Carrie, lots of creative options for disbursement costs. What are you saying?
Yeah, I always want to make sure that, when people are trying to unlock things or get access to money, that we're not triggering tax. It's one of the things that people go, well, I'll just cash out all my RSPs and everything else. And it's like, can we just talk about that first? That can't be our only access to getting funds and everything else. So wherever we can find a tax saving, not trigger a tax consequence, let's look at that first. Let's see if there's other ways of doing things. Again, if you're in collaborative, Natalie's already mentioned, I love the idea. You have a joint line of credit. Let's use that for process. If we have that available to us, it's a great way of keeping track of what the process is costing the family. Because it's not just one person it's costing the whole family. I find when people can track that and look at it, sometimes it snaps them into reality. And rather than going, oh geez, I just have an open ticket here and I can spend wildly. We want to calm that down.
And we've had cases, Carrie, you and I, where my client was clearly paying something or everything, like a significant equalization payment, significant support obligation. And I just tell them, pony up 25 grand for the cost of the collaborative process. So your spouse can have a lawyer and professionals involved. It serves his interest to get a full team involved, and we'll adjust for it at the end. And most clients are agreeable to that.
Yeah, it's all reconcilable. Like nothing is going to be left to the side. We're going to look at all of it. So we're going to do things in order. And when we get there, we'll put it all together and say, great, you spent X on the line of credit. Your spouse spent Y on the line of credit. You spent the same. Great. Don't have to worry about it. That's how it'll get paid out. And we go from there.
But unfortunately, there are spouses and lawyers who use the finances to try to extract an unfair settlement or a settlement that isn't within the goalposts, right? And then we see this quite often when we're looking at expert reports, business valuations, income assessments. Like, why would I pay for you to get an income assessment to say my income's higher? Or, I'm not going to finance your litigation. And this is quite commonplace. And these can be, as we started off at the beginning, quite expensive. So Tim, is this something that they can turn to you for if we need a business valuation or an income assessment or an expert report?
Yeah, those are typically what we can assist with, and we also have a number of experts that we work with. So we're always looking to add more value to the relationship that we do have with firms, and we can provide referrals to certain experts if they're not already part of your roster.
Yeah, and there's a number of other things that fall under this category, right? Family professionals, voice of the child reports. Property appraisals, medical reports could actually get quite expensive too if if you're doing a vocational assessment. So yeah, that adds up. All right, well, thank you. That's clearly there's a lot of challenges. I think we can all agree on that our clients are facing at every step of the case, and financing it. We need to be creative. We've heard Carrie come up with some ideas in that too, and Tim's here to provide a third-party solution. We cannot obviously do contingency fees in Ontario for family law for a number of reasons, but we don't want lawyers taking an interest in a case, especially if it involves parenting or the child's best interests. So let's turn for a minute to retainer agreements. I remember when I first started practicing, going back, story time, there would be these lawyers who would tell clients, just give me $500, right? And the secretary would go in the parking lot and meet with the client and get an envelope of cash. And I'm sure they kept it off the books. And every now and then the lawyer would say, oh, I need another $1,000. Like, this is old school family law, right? It's hard to believe, but it's true. It wasn't me, but there's a number of lawyers, especially in small communities. It's just the way they operate. But you need to have a standard retainer agreement, right, Nat? It needs to be pretty thorough.
You do. I've never operated my practice out of my van.
In your van down by the river. There's a Lincoln lawyer, right? You run around in your car, and there's lawyers like that. You see them all the time coming into court with their grocery bag of court documents. I'm not naming anybody specifically, but I could. So what do you want to include in retainer agreements, Nat?
Quite a lot, to be honest. I think people are astounded when they receive their retainer agreement because it's quite lengthy and it contains protocols of the firm, how we conduct business, what we expect of our clients, how they can achieve a cost-effective resolution by engaging in rules of conduct. And as well, it details all of the payment terms, how they'll be charged, what they'll be charged for, and how the trust account works that we work against in terms of invoicing, and when they're entitled to get money back if they decide that they want to end the relationship with their lawyer or if their matter is finalized.
Yeah, and you can include a lot of non-financial things, right? Warnings about their use of social media and how it can come back to haunt them in court. Appropriate communication with not only our office, but other parties, and privacy and security. It covers a number of things, not just you're going to pay us X number of dollars to do this.
It's like a mini tutorial, Russ.
Yeah, it is.
Family Law 101.
The more detailed and thorough you can make your retainer agreement, the better informed your client's going to be. And it's going to clearly define what your relationship is. And if you're doing unbundled legal services, you want to be very specific in terms of the service you're providing, because the client may just think, okay, you're my lawyer now, and you didn't specify it was only for the financial statement that you'd help me with. And you want a mechanism to get off the record in case there's a breakdown in the relationship. Evergreen retainers are becoming more popular. If you're not familiar with an evergreen retainer, for example, you'd pay us $5,000. Once we render an account, you're required to top that back up to $5,000. So the account never goes into the red. There's always money in trust. And if you don't top it back up, we end our representation of you. So a lot of lawyers, and I've seen this many times, will take the $500. 2 years later, they get fired for whatever reason. and the account comes over to us, and we realize they've never rendered an account. They have like a $4,500 AR and an upset client. So they've worked on the file for 2 years, and now they're not going to get paid. Or if they do pursue a payment, there's likelihood there's going to be a complaint against them. So really difficult situation when your client owes you money and you need to collect and still continue to work. Many clients can't catch up again. So that's why these evergreen retainers are really, in my view, a really good practice tip. But have you used those before, Nat?
Sorry, contingency fees, do you mean?
Oh, the evergreen retainer where they're always
Oh,
required to
absolutely.
Yeah.
Absolutely. That's the only retainer that I've ever subscribed to. People need to have money up front, ready to pay for your services. Otherwise, you're potentially leaving yourself in a bind.
Yeah. Nat, in terms of retainers, you have any, or sorry, Carrie, do you have any experience with security, liens, directions, promissory notes? Do you ever return to those?
Yeah, actually, we just did that. We've had some matters where, they've been good payers all along. They've done a good job, but we're coming to end. They're running thin on funds, but we know the home has been sold. We know the closing date. And so we do get them to sign directions to all of us saying the first people getting paid out of this are the legal team. And we actually just did this last week. No problems. The clients were really thankful about it because it was just a pressure point that was taken off of them because they knew we were going to get paid. It wasn't going to be an issue. They were going to get their documents on time so that they could close on their new homes that they had already purchased. So we do that. The other thing that we've had to do in the past is we've actually had to put people into collections. Just simply, you're not paying. And we keep everything that we send out and get in. And so when somebody says, oh yeah, I'm gonna pay you, and 6 months later, they still haven't done anything, we kind of go, well, our next resource is this. Like, this is the only other thing that we can do is put you into collections. So
Collection agency or collections?
collection agent. Well, you go through a collection agency. I always figure, you know what, even if I'm only gonna get 70 cents on the dollar, it's 70 cents more than I was gonna get if they never paid me. So you take your lumps for not doing an evergreen retainer. But one of the things I have in my retainer agreement is that you will give me a valid credit card to put on file, and if you don't pay, I get to charge your credit card.
Yeah, that's a good point too.
So.
Yeah, directions could be a great tool to get people over the hurdle, especially if you're 95% of the way there, homes closing in 30 days, loss of equity.
Yeah.
It's a convenient, and it's, you want to try to get the clients to a final solution. So that's a great way. We've done liens and mortgages before, inconvenient, lots of delays. Oftentimes I forget about it, and then somebody goes to sell the house and they got to pay out our lien, which is kind of a nice bonus, but it comes in 3 years later, right?
Yeah.
And we've already written it off the books. And promissory notes, I'm not a fan of, really. Even directions can be dangerous. They can reverse the direction or not honor it, or so even if it's irrevocable. So certainly some risk associated with that. Did you want to add to any of this, Nat?
I would just say there's a certain level of accountability, I think, that I prefer in imposing an evergreen retainer, because people quickly come to realize that they are very much part of their process. They can either be part of the solution or they can be part of the problem. And once they recognize that they're going to have to keep paying, they quickly change their behavior, I find. So.
That's a great point, Natalie. And I don't think people understand that sometimes we just stop working. Like when we have a threshold that when the account gets to a certain threshold and we have not been paid, or we're having trouble getting paid, we just stop work. We just say, until this is brought up to date and we have a new retainer, we're not working on your file anymore.
Yeah, the collection, at some point, we just write it off. We may send it to a collection agency to collect. We don't care anymore. It's off the books. But, damaging the client's credit rating, they came to us to help. I'm not sure if I want to make things worse by damaging their credit report. I think that might, for me personally, that might be going a little bit too far. we want to try to help them through it, but yeah, everybody's got their own choice. Tim, what kind of security you put in place, or what was common when we go to third-party financing? What should our clients be expecting?
Yeah, I mean, what we typically do is we'll register a PPSA on the client. And then also if there's a matrimonial home or property, it's not a formal security, but we do register one just to ensure payment upon resolution, and the eventual equalization payment from the sale, proceeds from the sale of that property.
Yeah, so there'll be some documents for them to sign, obviously, right?
Yeah, yes, we have, we issue a few different documents. We have our loan security agreement, which runs through everything. And that also, because we can provide funding in a few different types of ways, it just illustrates how that's done. And then we also have an irrevocable authorization and direction, which also goes to the law firm. And then we just have simply a direct deposit form as well, just to make sure that that the funds are going to the client, but we can also provide a direction that they be sent to the law firm as well if it's to cover legal fees or disbursements.
Right. So we got a poll coming up here in a few minutes. Next topic is common approaches. So let's not put the poll up yet. Sorry, Shannon, I don't know if you can take it down. What I want, you can put it in the Q&A box, is what's the most common way your clients are financing litigation? And we'll read some of the audience answers off as they're plugging them in there. But let's start with maybe you, Nat. What are you seeing? What's most common in terms of the different approaches that we've talked about today?
I would say typically they use their credit card or the line of credit to fund their process.
Yeah.
That tends to be the go-to. Sometimes they rely upon friends or family to provide a source of funding. Sometimes we come up with creative solutions as well as collaborative professionals, don't we, Carrie?
Absolutely. I think that's the best part about doing collaboratives. We get to be creative.
I used to have a couple clients, they'd always want to pay in cash. And I don't know where the cash was coming from or what kind of industry they were in. And it was great, but then we had our limits, right? My clerk would say they're at their $7,500 or whatever the number is, and I'd have to say you can't pay us any more cash. I'm sorry, kind of a strange position to be in, right? But how about you, Carrie? What are you seeing? What's the most common approaches?
Same line of credits. What we've done though with some clients, because we want to give them a little bit of fun strategies that we can use, is that put it on your credit card, then pay that if you can with cash, like pay it out if you can. If you can't, use your line of credit. At least get some points. So maybe at the end of this, you have enough points to go on a vacation. I always say you gotta get something out of this. So, but we do. Line of credit is really, really common. Sometimes putting on credit card, then paying it out. But family and friends. Family is huge. Friends are a little less, and that's okay. I don't know how comfortable I would feel about going to my friends for money to fund my divorce, but definitely family. Parents are really big about protecting their kids, no matter how old.
You may want to get a direction or authorization from your client to communicate with family members when they're paying, because sometimes they'll want to ask some questions too, and we're not allowed
Well,
to with them. So you want the client's consent and authorization to do
well,
that.
I think we have to be careful if parents are paying us directly, the parents do have to understand it's simply a payment situation. You're not
They're
getting
not get-
say in the matter.
not
You're
getting-
not participating. You're not coming to
You're not getting-
meetings.
You're not getting a report.
Yeah, go sit in the corner. Thank you for your money, but no. Take this up with your kids.
Well, we're remote quite a bit, so it's quite common e-transfers, certainly credit cards. Some, like you said, Carrie, some clients want to crank up their points, right? They
Yeah.
could transfer it, but they want the points on their card. Usually escalates the line of credits, but oftentimes when it comes to separation, usually the credit line of credit's been maxed out by one party or their lifestyle, and then at that point, they usually flip over to family and friends.
Honestly, though, if you have a joint line of credit, you're in the collaborative process, especially, or you're in a mediation process, it is a great way to track how much this is costing you between your professionals, any experts that you need, anything like that. And it is a really big dose of reality, especially if it started at 0 on data separation and now it's up to 50,000. You can see where all your money's going and why. And I think it's a great way for people just to kind of keep their pulse on what spending is.
I remember, in my advice is going with the blank sheet and just be open-minded. When I remember we had a call come through, client didn't pay his child support, was way behind, had a hearing with Fro, and they're suspending his driver's license. Very short timeline to get a refraining order. And one of my associates said, well, why would we take this client on? They've got no money, they can't pay us. I go, I'll meet with them, right? And we literally had to be in court within a day or two, which means we're going to drop everything to work on this one client. We all get clients who come in like this. And I told them, it's going to be at least $10,000 to get this sorted. And you have to go on a payment plan probably to get your driver's license to avoid it from being suspended. He said, sure, no problem. He had the money, he just was choosing not to pay his support. But he certainly had the money to pay for a lawyer. So even though they may look desolate on your intake forms or their financial statements, does not mean that they're not going to be able to finance their litigation. So be open-minded, be optimistic. We're here to help. And you'd be surprised what clients can do, especially when they're jammed up. They're going to lose their license and potentially their job. So CP approaches to financing. Carrie, can you give us a few examples of how you've been getting creative?
Sometimes it's a matter of one party paying up front. They're going to be paying, maybe we have a stay-at-home parent, the other person has a job, they have been having, I don't want to say control, but they have been managing the money for the family. Maybe it's a matter of them paying up front and then we're reconciling it later. That's a really common one that we've done. Sometimes if we know one party is going to be paying the other party an equalization payment, it's really clear that that's going to happen. Let's do a prepayment up front so that they feel that they have control and anonymity to go ahead and deal with the team on their own without feeling like somebody else is doing that for them. So those are just a couple.
Yeah, any creative things you've seen in the collaborative process?
So sometimes the team can agree upon doing block fees. If people are well aware of how much it's going to cost in advance for one meeting or one particular event or step, I find it helpful for them to just be able to manage or control how they're going to pay for it in advance. So it's a matter of financial planning. And then quite apart from that, I guess it's pretty typical, but often they'll take a mutual advance from the net proceeds of sale. And that can be helpful as well if there's a credit against the final settlement.
That's quite common. Judges will order the release of funds, usually equally, right? $50,000 each or whatever the number is. But you want to be careful you have enough left over to pay the equalization payment too, right? You generally have a good sense in terms of what the payment's going to be. So you want to
always keep money in reserve. Always keep money in reserve.
But we've got a poll here. Have your clients use third-party financing to fund their divorce or separation? Give everybody a minute to answer that. But I really like your answer there, Nat, about block fee services. And Brian Galbraith has been advocating this for years. But the way it works, the lawyers say, okay, we're going to take $7,500 each. The professionals are going to say, we're going to take $2,500 each. And that team agrees to meet once or twice to do the full collaborative process. And it's paid up front. And it's quite effective. And what clients like about it is they can control their costs, right? So you go to get your kitchen renovated, that your carpenter doesn't say, well, I'm going to charge you this amount an hour. They're going to say it's going to be 25 grand or whatever the number is. So they're used to this concept of block fees for big purchases. Or if you're putting a pool in or getting work done to your driveway, it's not by the hour. Your driveway is going to cost you $10,000 or whatever the paper says. So it's quite common in other industries. Lawyers haven't really warmed up to it too much, but and sometimes you run long, right? Not so you say, well, if you want us to do an additional meeting, this is going to be the additional fee.
Well, and the beauty of it is that we can customize the length of the meeting for the clients and what exactly we're going to discuss. So it just takes
Right.
planning as a team to actually formulate an agenda that's feasible within the budget of the family.
Yeah, and there's great precedence for block fee collaborative practice agreements. If you need some, let us know, send us a note. But it's certainly a different way to approach financing family law disputes. All right, let's see what our audience is thinking about third-party financing. Yes, 33%. No, 59%. What is third-party financing? 4%. And other, put it in the box. We've got an interesting article and some case law we're going to share with you in a moment. But I'm going to flip this over to Tim. It's sort of your lead in. Tell us what this is all about. What should we know about third-party financing?
Yeah, thanks, Russ. One thing I would like to do is briefly just address something that Carrie had said earlier with regards to line of credit. We do offer our funding as a line of credit as well. And I just wanted to jump on her point that it does give great visibility on budgeting and also not abusing the time that you're spending with your lawyer. When you're on a deferred payment plan, or if the firm's not doing micro billing, clients can lose track of how many times they're interacting with the lawyer, what they're requesting, reaching out constantly. And that's where things can kind of get out of control. And that's when you have issues where there's, conflict at the time of billing. So the line of credit is a fantastic way to sort of manage that and have full visibility for the client. And then, the secondary benefit is with a line of credit, you only pay interest on what you use. So I think that's what we recommend with regards to our funding going forward.
All right, so let's learn about BridgePoint. What's the application process, loan documents? How's it work?
Yeah, so it's a simple application. We ask for a few details. It's basically an intake form that gives us some good background information. We then reach out to the applicant, your client, and just get more information that is valuable for our underwriting team to get a sense of the situation and what the eventual entitlement or equalization is going to be. Their financial status, their liquidity, the assets that they have, and that gives us a real sense of what we can lend against. So that's the first part of the process. They also provide us with permission to speak with their lawyer. We like to keep this as light a touch as possible while getting as much information as we can for the underwriting process, because we don't want to, have the client incur fees and time with the lawyer, but we also want to ensure that we have a full picture of the situation. From there, it goes into a review with our finance committee. And we go through all of the information. We've got a very experienced legal team that reviews everything. And then we provide the funding. So the loan documents, so that's the loan security agreement goes to the client, and the irrevocable authorization and direction goes to the lawyer. And after that, the funds are deposited and repayment is due, and then that's typically via the law firm's trust account at the time of resolution of the separation or divorce.
All right, we've got some questions coming in. What's the interest rate for BridgePoint is one of our audience questions.
Yeah, we can be fairly flexible on that front, and that's typically we look at complexity as well as duration. But at the our base would be 1.5% a month, and that's compounded biannually. Yeah, there's no other fees associated with that.
All right, a couple more. Somebody's looking for a precedent for a retainer agreement. You can contact our support team. We'll help you with that. Another question came in. What collection agency do you recommend, Carrie, if any?
I can send that over to Shannon so that you guys can send it. I don't have them off the top of my head. We don't use them a lot. That's a good thing, but we do have one that we use.
Another question looking for block fee retainer agreements. Again, contact our support team for that one. And great questions coming in. Thank you so
Can
much.
I ask Tim a question?
Yeah.
My question for Tim is that if somebody's in collaborative process and they're having to pay for their lawyer, but they need to pay for somebody like me, the financial professional, or they also need to pay for a family professional, can they use their your situation to pay for all the members on the team?
Yes, the client can use the funds however they choose.
Okay.
So, as we talked about earlier, those tend to be legal fees, alternate living arrangements, personal expenses, that sort of thing but it's up to their discretion.
So vacations.
Well, that would be
Get away from the
irresponsible.
spouse.
If it's in the best interest of the child, it's got to be a Disney vacation.
There you go.
You have your hand up, Nat?
Yeah, I just wanted to say, honestly, I found the earlier that we inform people about BridgePoint financing, the better. And so
Yeah.
I make it a point during my initial consultations to raise it, particularly where a client is saying that funding is a concern, because then it enables them to at least investigate their options early on.
Mhm.
You know
can give
what?
us some-
I think it's great for somebody like me where so often we are the first point of contact now, and they're telling me I can't afford a lawyer. I can't do this. So if I can point them over to a BridgePoint, that makes my job a little bit easier. I don't want to deal with a client that doesn't have a lawyer. And that I
Yeah.
think everybody needs really good legal advice. So I'm not going to take that client on. But if I know that there's a way that we can get them through the process and pointing them over to BridgePoint, I think it's a great idea.
I don't want to deal with an opposing party that doesn't have a lawyer.
Well, yeah.
Me neither.
But
So we're all on the same page. Lawyers are necessary for the process.
now you can give us some case studies. You've used this before for your clients, right? So what was that experience like, and what were some of the issues you were funding without naming names?
Significant need for funding for arbitration most recently. Honestly, it's a lifesaver for people because they get to a certain point within process where they realize they're going to need a decision maker to get to a final outcome. And often they have no idea what they're going to do to fund that. And so, yeah, BridgePoint was a lifesaver in that case.
Yeah. And we do have a case in Ontario where part of the cost claimed was litigation financing by a third party. And the judge authorized the interest on that cost, even though it wasn't agreed to or in advance from the other spouse, but they thought it was an appropriate disbursement to finance litigation. And Shannon's going to put that case in the reported case in the chat. And there's also an article about litigation, third-party financing. So I think this is the trend we're going to start seeing. It's especially important when we look at how many unrepresented or self-represented litigants there are in the family court system. I'm not sure what the numbers are, but if I had to guess, it'd probably be over 50%. Would you think that?
I think that's accurate. It may even be
It's probably
more.
conservative, yeah.
Yeah.
So all these people who could potentially be accessing legal services and don't know that this is an option really need to be educated about this. And if it means that they're going to incur a little bit more interest, that's potentially a claim they can make if they're in a cost submission, if their case is successful, that had the other party settled earlier or accepted an offer to settle, the litigation financing would not have been required. And I think that's a pretty compelling argument. So something to consider. All right, two more questions for Tim, and then we'll move into final thoughts. This has been a great discussion. This is probably one of the most difficult issues facing our clients is financing. In addition to all the different stresses that go through a separation divorce. If we can get that off the table and say, you're financed, we're ready to help you and follow through on this, I think that's going to go a long way to helping clients sleep at night and helping with their mental health. But a few quick follow-up questions, Tim. Are there restrictions on what family law financing can be used for?
No, as we talked about earlier, it's up to the client's discretion. Obviously, we prefer it's used for, things that are going to advance the process, or get them out of a situation, live with regards to living arrangements, but ultimately it's at their discretion.
All right, we have a few hundred lawyers watching you today, so no pressure. How does the client qualify for the financing?
Yeah, so we've got, when we work with firms, we do have, we've got our term sheet, a product sheet, and we also have key factors that contribute to a successful application. It's quite a long list and detail, but the high level is, the borrower is represented or will be by a lawyer. The borrower resides in Canada. The matter is governed by Canadian legislation or courts. And then there will be a triggering event for repayment is key. So if that's a jointly owned property with sufficient equity that's going to be sold or brought out by one party to the other, if there's going to be a cash equalization payment made from one party to the other, or a property will be financed and the loan will be repaid from same. Duration and complexity of issues is a large factor for approval as well. And then we also require sort of general information for the application, things like ID, lawyer information. If there's properties involved, we'll need all the documentation there as well as, business evaluations, spousal support calculations, the separation agreement, ultimately, pension statements. But, those documents are, based on the unique facts of each case. But that's typically what our finance committee is going to look at. That's what we typically look at, but we can also look at borrower's income or any other assets, like on an informal basis to review with our team.
That's super helpful. I think I got a quick minute left, so I want to get some more questions in here. Does the lawyer have to provide guarantees on the funding? And are there any, or is the lawyer tied in any way to the funding?
No, not at all. The lawyer is not involved and doesn't have to provide guarantees. Like I mentioned earlier, we want to be as light a touch as possible while getting all the information we require. So we do like to work collaboratively with the lawyer, just to ensure that we have all the information we need. Internally, we have a policy called our responsible lending promise. So we never, ever want to provide funds on claims that aren't meritorious. So that's extremely important for our business. But the lawyer is not liable in any way.
Okay, good to know. Super helpful information. Thank you again for the sponsorship towards the Denise House. We are very close to our numbers, so that was really generous of you. Thank you for that. I also noticed that Ravinder just made a donation. Thank you, Ravinder. Any final thoughts or questions on financing family litigation? Carrie, you want to go first?
Sure. Just a couple of things. First of all, this going through separation divorce is going to be one of the largest financial transactions that you will ever do in your life, from the home to pensions and everything else in between. So you do need to be prepared for that. Having said that, old data, although I don't think it's changed too much, is about divorce is about 67% more expensive than the wedding was. So keeping that in mind, it's going to cost some money to get through this, and you want to make sure you're doing it right because you only want to do it once.
Don't forget the divorce party too, right? That's common.
Oh, well, yeah, that's the added.
Nat, final thoughts?
Just that I love the flexibility of BridgePoint, and it's fantastic that they can use the money as they deem necessary for whatever purpose, because sometimes there's unexpected expenses that arise, like the need for criminal counsel. So not only paying your family law lawyer, but criminal counsel as well, if there's family violence at play, as well as therapy. I think it shouldn't be overlooked. Therapy helps us resolve our cases, keep people, honest and transparent.
Yeah. I know I'm heartbroken sometimes when clients run out of money and can no longer fund their case and they have meritorious claims. So this is a really fantastic option to be able to present to them. Tim, any final thoughts before we hand it back to Shannon?
Yeah, just a couple of things. I know we didn't have time, but I do have a number of case studies that really illustrate different ways that can be leveraged during
Well,
the.
let's take 2 minutes quick. Give us a couple of your case studies. I don't want to rush you through it.
Yeah, and just as a footnote to that, I'm happy to provide these to any of the attendees as well.
Yeah, we'll include them with our show notes.
All right, wonderful. So I've got one here just for living expenses. So the facts of the matter are that the parties were still living together in the matrimonial home. However, domestic abuse was present. The female partner or wife was unable to move or retain a lawyer to commence the separation process as she was on disability and did not have extra funds available to her. The parties had significant assets, including 2 properties, which were jointly owned, and a couple different investment accounts. The borrower was able to secure a loan, which allowed her to move into her own apartment and retain a lawyer who began the separation and disclosure process. The lawyer was able to assist with the commencement of spousal support, and the borrower was able to escape domestic abuse. We provided a lump sum of $10,000. $5,000 was provided directly to the borrower, and $5,000 was provided directly to the lawyer in trust for his initial retainer fees.
Nice.
Yeah.
That answers one of my questions. So the client is financing, the money goes to the client or to the lawyer, or it depends what the client directs.
Exactly. Yeah. But the client can direct the funds to the law firm to take care of a retainer or any outstanding legal fees.
Okay, good to know.
And
Any
then
other case studies? Those are really helpful.
Yeah. Well, I've got 8, but we don't have time for those. So let me be discerning here. So another one is the borrower and her partner were married for 20 plus years. Upon separation, the matrimonial home was sold. The separation agreement had already been signed. However, the borrower did not have funds to secure her own rental apartment, as she did not have cash in hand, nor did she have credit to secure funding prior to the closing of the home. So essentially, she was going to be homeless in this scenario. So we provided a lump sum of $55,000 to the borrower, and that allowed her to secure a rental by paying 1 year of rent up front, which was required due to her credit situation. And that also assisted with personal expenses, which was repaid upon the closing of the property 60 days after the loan was provided. So both of those really speak to living expenses. There are legal fees at play there as well, but we do have a number that are just dedicated to legal fees, as well as the ones associated with litigation.
And you're really helping clients in crisis, right? That person could have been homeless.
Yeah, I mean, BridgePoint started in 2005, and it was based on access to justice. When we did start working with family law firms, we realized that the same situation was happening in family law, where there was access to counsel, a big access to counsel issue, which ultimately ended up being access to justice. So it was an ideal area for us to assist with.
Yeah. Well, you're providing a super valuable service. Thank you, Tim. Natalie, Carrie, Tim, thank you so much. Great job,
Thank
Shannon.
you.
We're going to see
Thank
everybody
you.
back here at 12 noon.
Thank you very
Always a
much.
pleasure.